How do you protect a name that you have come up with for your business? Whether it's the name of the business itself or the name of certain products or services. The point is that when you've come up with something that's really unique and special, you don't want any of your competitors using that name or some sort of variation of it. The proper way to protect that name is to register a trademark for it. But how do you do that? Let's talk about it. Hey friends, welcome back to my YouTube channel. I'm so glad you're joining me today. I'm Faith Mitton, an attorney on a mission to simplify brand protection for entrepreneurs and business owners. On this channel, you will find tons of free, easy to understand, and practical insight about trademarks to help you get a better sense for how to protect yourself and to stay on the right side of the law. Now, in terms of protecting yourself, that also extends to your business and your business names. And trademarks are a fantastic way to protect those names. So how can you use trademark law to safeguard the fruits of your creative genius? Well, there are three things that you want to think about when it comes to trademark protection for business names. First, you want to make sure that you have chosen a name that is worthy of trademark protection. Yes, friend, not everything is eligible for trademark protection. There are levels to this, and certain names are considered to be strong trademarks, whereas others are considered to be weak trademarks. And some names don't function as trademarks at all. In order for a name to function as a trademark, it must tell people who the source of a product or a service is. So certain things cannot function as trademarks because they don't do that. I have a whole other video on this channel about strong versus weak trademarks, which I will tag here and link to in the description. I won't go into too much detail here because that'll make this video too long and I want it to be a short video. But in that video, to quickly recap, I talked about fanciful, arbitrary, and suggestive trademarks as examples of strong trademarks, and descriptive trademarks being weak trademarks. Fanciful trademarks are made up words. Arbitrary trademarks have no logical connection to their products and services. And suggestive trademarks hint at or imply a connection to their products and services. Descriptive trademarks, on the other hand, say something really obvious about the products and services themselves, the target audience for the products and services, or the company behind the products and services. Watch that video for more detail and examples. But back to the topic of this video, take the time to assess whether your trademark is fanciful, arbitrary, or suggestive. If so, move on to step 2. If it is in the descriptive category, consider rebranding to get into one of the higher, stronger categories in order to seek protection. Number 2, in terms of protecting a name that you have chosen for your business, consider whether to start using the name to sell your products and services. This is not a definite yes or no. This is consider, right? There are some people who feel like their names are so unique that they do not want to publicly launch their brand until they've made some sort of legal filing to protect the name. That's totally fine. There are other people who are like, I just want to get my brand out there as soon as possible. So I'm going to start selling my products and services, and then I will make a legal filing. That's also totally fine. The reason why I say you might want to consider going public with the name that you have chosen, not just posting it on social media and saying, hey guys, I chose this name. Isn't it cute? No, not that. What I mean is publicly associating your name with the products or services that you sell, because that is considered trademark use, and that kind of use is necessary to acquire trademark rights in the US. So what do I mean by publicly associating the name to your products and services? Well, that could simply be setting up a website where your trademark is in big, bold, large font that it's easily visible and in close proximity to whatever it is that you want to sell under that trademark. When you do this, when you begin to publicly associate your trademark with your products and services, you begin to acquire something known as common law trademark rights. Common law trademark rights come into existence without making a legal filing. They provide a degree of protection for your trademark only in those places where you have market penetration, right? Where you have sold your products and services, but it provides some limited protection for your trademark rights. And it helps to establish use of your trademark for when you do ultimately file a trademark application. Whether you should launch publicly first and rely on common law trademark rights, or make a legal filing first and then establish trademark use after is a decision that you should make in collaboration with your legal counsel as part of your overall business and legal strategy. Because there are some folks who don't want to launch anything publicly because they have legitimate concerns about someone stealing or misusing or executing on their chosen brand before they have a chance to fully launch it. But there are other scenarios in which going public as soon as possible with a new brand is highly beneficial. So it's important to get the appropriate counsel to make the right choice for you. Once you have determined whether the name that you've chosen is worthy of trademark protection and you've made a decision about whether to launch it publicly or not, the ultimate thing you should do, number 3, is to make the public trademark filing for the name. This filing is normally done through the USPTO or the United States Patent and Trademark Office because the filings that are done through this federal agency, if approved, will provide protection for the trademark in the entire country. Mind you, there are things known as state trademarks. The agency that registered your LLC or corporation may also offer you the opportunity to register a trademark. But note that these trademarks only provide protection for the states where they are registered. They do not cover the entire country. So if you're looking to establish your exclusive ownership over and legal right to use the name that you have chosen, you will want to go in the federal direction by filing with the USPTO. When you make this filing, you will have 2 options: the standard character mark option and the design mark option. If you apply to register your trademark in standard characters, it means that if the trademark application is approved, that you will have the right to use that trademark in whatever format or style that you deem appropriate. However, if you choose to register a trademark for a design mark, the trademark, if approved, must only be used in the relevant design in order to maintain protection. So examples are always good here. Coca-Cola has a standard character mark for that name. And that means that the owners of the Coca-Cola brand can present that word Coca-Cola in whatever format, font, or style that they desire. However, they also own a design mark for the Coca-Cola in their special script font that is unique to them. If Coca-Cola did not also own the standard character mark, and they only own this scripty design mark, that would mean that the only time that they had protection for that Coca-Cola word would be when it appeared in this specific format. And if they change the format in any way to present it like this or like this, they would not have protection. So when you are choosing which trademark application to file for your name, be mindful of the difference between standard character marks and design marks. There are many companies that choose to layer these on top of each other, like Coca-Cola did, and register both standard character marks and design marks for the same exact thing to give themselves the maximum flexibility and to maximize their protections. But if your budget is limited, you may want to register for the standard character mark to give yourself the ability to change the format without losing your protection until such point at which it makes sense for you to file any design marks for your name. And be mindful of the fact that when it comes to trademarking something, that's actually a misnomer. It's not quite possible to trademark something. You can register a trademark for a name, but you cannot trademark it. Just because you were able to successfully register the trademark with the USPTO does not mean that there's not somebody else out there who has common law trademark rights in a similar trademark. So this is why prior to filing your trademark, as part of your analysis to figure out whether you're going to do a standard character mark, a design mark, or both, it's important to do a clearance search to vet the trademark and see whether it is available for you to use and register. A trademark attorney can help you with all of this, figuring out whether you have something worthy of trademark protection, determining whether and how to establish use of your trademark, and then figuring out which trademark application to use after you have done a clearance search and make sure that there are no trademark conflicts which would prevent you from being able to use and register that trademark. Because what you don't want to do is rely on a video like this, which just provides a summary of some things for you to consider, because like all summaries, I have left a lot of things unsaid. So instead, be sure to consult with your own trademark attorney when deciding how to protect a name that you have chosen for your business. And that's a wrap. If you enjoyed this video, I hope you will give it a thumbs up. Please be sure to subscribe to the channel for more trademark content and to turn on notifications so you never miss when I post a new video. If you've got thoughts or questions to share, please drop them in the comments. I read and respond to each one personally, and I would love to hear from you. Thank you for watching. Stay tuned for the next video.